Let's just move on to what has been quite a hot issue, and I know important to a lot of you, important to me, in fact. This is the issue of the jurisdiction of the Broadcasting Standards Authority, which have, after 3 years, has suddenly said, I didn't get a memo that it put out before the platform existed saying that it had decided that it covers everything on the internet, or what it thinks looks a little bit like a media company if they bend their tongue, stand on one leg and squint. This comes as a result of, and I just want to make a shout out, a guy called Richard Fantonslow, who is some sort of, I don't know, he does some access for charity worker, who wrote to me a while back and said he didn't like me using the term, I think tikanga is mumbo jumbo. He thought that was racist. He wanted to lay a complaint under the Broadcasting Standards Act. I told him that he was a plonker because it didn't apply to me. He runs off to them. They say, oh, we've got a complaint about Mr. Plunket being racist. Let's tell him that he's under the Act and ask him to respond. And there's quite a lot of stuff. And then they went and had some secret hearing. Anyway, Richard Fanslow, you've written a really weird and rambling 2 and a bit page email to me and to Jelaine Heather from the Free Speech Union. I'm inclined to publish it and read it out, but you're obviously a loyal listener. You've obviously taken the decision to download the app or go to the website. So, Richard, I'm going to offer you, before I publish or read this out, if you want to ring in this morning on 0800 332283 and discuss your concerns, I'm more than happy, Richard, to take your call. Otherwise, we'll just publish your rant. All right? Just giving you the choice, because I'm a reasonable non-broadcasting man. I just want to say, if during the course of the debate that we're about to have, you're concerned about anything, I want to make it clear how you complain here on the platform. Just listen to this again. We've been playing this ever since we went to air 3.5 years ago. Have a listen.
A message from the platform founding editor, Sean Plunket.
If anything you've heard or read on the platform has offended, disturbed or upset you, or if you believe we've breached any code of broadcasting standards, tough. You can ring our talk line on 0800 Debate and have a yarn about what's upset you, though.
None of your tax dollars were used in the production of this message. Brought to you by the platform.
Now that we've got the rules laid out, I want to explain what's going to happen. We have joining us two, I think, very, very good legal minds who have got different views on the issue of the jurisdiction of the Broadcasting Standards Authority. We have Judge David Harvey, retired, who has been a law lecturer, a media law expert, and I would say is an expert, and also Stephen Price, media lawyer, who's also an expert. I used to work with Stephen on, he used to make sure at fair go that we did comply with the Broadcasting Act. And he's also done some work for the BSA, though not on this issue of issues of freedom of speech. Gentlemen, good morning to you both. Thank you for joining us.
Thank you, Sean. Good morning.
All right. Now, the way this is going to work, and as I've explained it to you, and I haven't got someone with a stopwatch, David is going to explain his position, Stephen is going to explain his position, and then the two of you will debate fine or indeed blunt points of law. And I hope we shed some light through this korero, through this discussion on what is going on. I want to thank you both before we start for agreeing to come on and take part in this. It's good to have people who probably know more than I do about what we're talking about. All right, so Judge David Harvey, let's start with you. What are the issues and what are your points, the points you have to make about this, well, brouhaha, this issue?
Okay, Sean. The Broadcasting Standards Authority has issued what they call an interim decision or an interlocutory decision, which is quite interesting in itself. And in fact, I think that raises a procedural problem because it suggests that, in fact, the matter has been predetermined. And they have called for submissions rather than suggested that there's been a complaint and perhaps they would like to hear the argument about jurisdiction before deciding it, because it would seem to me that this is one of these sort of Wellington-type consultation things where the decision has already been made. That's the procedural issue, but there are a number of other issues as well. The first thing is that I think the platform may be like the radio, as I think the CEO of the BSA stated, but it's not broadcasting as defined. I think that the CEO of the Broadcasting Standards Authority is somewhat lazy and legally wrong to say that it is broadcasting because it resembles broadcasting. That would be what I would call the walks like a duck form of statutory interpretation. And what in fact is the issue is that broadcasting has a specific technical meaning within the Act. It's either transmission by radio waves, which the platform is not, or other means of telecommunication. Okay, so radio waves or spectrum are not used, but the way that the platform transmits is not through telecommunications, but through internet protocols. So it's not addressed by the Broadcasting Standards Authority. They have lightly skated over this particular problem of interpretation that they have used. But to grant jurisdiction, they have to bring it within the legislation, and I don't believe they have. You see, internet protocols are not telecommunications. For example, WhatsApp is not a telecommunication. It looks like a telecommunication. It works like a telecommunication as far as the user is concerned, but technically it is in fact voice over internet protocol. So it is sitting on top of the internet, just like internet radio. Internet radio doesn't use telecommunications channels. It doesn't use the telephone network. It uses the internet network, which is completely different. It is an on-the-top service. It operates on top of internet infrastructure without actually contracting with telecoms carriers for their broadcasting services. So internet radio really is an information service rather than a telecommunications service. Now, Stacey Woods of the BSA talks about broadcasting over Wi-Fi, but Wi-Fi, in fact, is narrowcasting, particularly if it's 5G. It is not broadcasting. So it's a completely different type of technology. And the whole issue here is understanding the technology. So it's facile, I would suggest, to assert that it seems to include an internet-based facility because the technology says otherwise. Since 2013, and certainly up until February of this year, it was an accepted position, other than by the Broadcasting Standards Authority, that internet radio, so-called, is beyond the ambit of the Act. It is for that reason that regulators have been working towards a new regulatory framework, and the Arts and Culture brought out suggestions for media regulation in February of this year, which clearly indicated that internet radio needed to be addressed because there is a regulatory gap there. And that regulatory gap has been recognised since 2013 by everybody other than the Broadcasting Standards Authority. But the real issue is that it's a technologically different way of transmitting information. So it's like radio, but it isn't technically broadcast radio. It's internet radio, and there's the difference.
Is that it, Judge?
That's it.
That's it? Okay, thank you, David. All right. Listening to that was Stephen Price. I'm not going to interrogate that yet because I want the two differing views. I'm not going to say the two sides. There are probably more than two sides to this argument. I just want these guys to present their thoughts. Stephen Price, media lawyer, joins us now. Stephen, what is your view? What is your view? How does it differ perhaps from Judge Harvey's?
Well, he's raised two issues. Should we deal with both of those in turn? The first one's the procedural one.
Well, let's see how we go. Yep, you can. I don't want you to rebut necessarily. Also, I know that you've written some stuff and have your own position, and I'd rather, in some ways, you present your position first, and then we'll talk about where those views differ.
Okay. Well, I think it probably is easier if I deal with those two issues in a row, because they've both arisen. So the first one's the procedural one, and I've got to accept that there is. I can understand how you might feel there's an element of prejudgment in being given a provisional decision. It is a provisional decision by the BSA that sets out a particular meaning and approach, and you're kind of on the back foot in responding to that. And it might have been better for them to just write to you and say, we've got this question about jurisdiction, what do you got to say? But on the other hand, if I was to defend the BSA about this, I would say, well, look, they about 5 years ago thought, well, there's a bit of a problem here. We're not really sure about our jurisdiction. We need to do some thinking about this.